Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. I am, of course, attorney Andrew Branca for the Law of Self-Defense. Thank you very much. Very, very pleased to be here. This is the second effort of us to do the show. We tried to do the show yesterday, and unfortunately, the local internet collapsed on us. We got a couple minutes in, and then everything went black. But it appears that everything is working fine today. So we're hoping that's the case. It looks like everything is streaming the way it's supposed to. So that's all good. Let's see. Here we go. Pin this up here. And we are ready to get things rolling. So the show today is going to focus on a police use of force event, the fatal shooting of a suspect. The police were called to a domestic violence situation, and they perceived what they believed to be a deadly force threat from the suspect, engaged the suspect with gunfire, and killed him. It would turn out that the suspect was armed with a magic marker. So what we'll be discussing today is the legal question. Does that matter? Should it matter that, in fact, the police who killed a suspect were not, in fact, facing a deadly force threat from that suspect? And we'll discuss it in both the criminal and a little bit in the civil context as well. With that introduction out of the way, let's see. Do I have my... Oh, I don't have my little video here. Hold on one second to do the formal launch of today's show. My little intro video. Can't start without that for sure. And it's going... Nothing but the highest production values here at Law of Self-Defense, folks. I know that's why you all come here. And here we go. All right. And here we go with the formal launch of today's show. Before I start, I should, of course, mention that we are sponsored by none other than Law of Self-Defense itself. And if you want to do yourself a favor, you can become a Law of Self-Defense member. Get unlimited access to all of our members-only content, including portions of shows that we do not stream publicly on YouTube, Rumble, Twitter, the other platforms that we use for our content. Because when there's some violent video content, then when we show it on those platforms, we simply get demonetized, creates all kinds of hassles for us. Makes it rather pointless to have distributed the content on those platforms. So that's where we find ourselves with that. Let's see. I forgot a couple little settings here. And this is one of those shows. So this police shooting was caught on police body camera. And so we have that footage, and I will share it on the show. And but that will only be in the members only part of the show. So what we'll do first is we'll talk about the scenario. I'll share a news report. We'll talk about the law that's applicable here. We'll answer the question of whether or not it matters that the suspect here was not, in fact, presenting the officers with a deadly force threat. And then we'll end the public part of the show, and we'll cut off YouTube, Rumble, and Twitter. We'll continue with only the Law of Self-Defense members. We'll show the body-worn camera, and there'll be additional analysis in the context of the body-worn camera video, because there's actually a lot going on in the video that I think is relevant to the legal analysis in this case. So if you want to enjoy that part of today's show, you need to be a Law of Self-Defense member. You need to be watching the show on the Law of Self-Defense member dashboard, where we also live stream the show. The good news is you can become a Law of Self-Defense member for only 99 cents. Get a 2-week trial membership for 99 cents, unlimited access to all our members-only content, including the second half of today's show. 99 cents, folks. If you don't like it in that 2-week period, you want your 99 cents back, we'll not only give it back, we'll give you double back. 200% money back guarantee. It's a negative risk proposition. And if you stay a Law of Self-Defense member after the 2 weeks, it's still dirt cheap, folks. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member and get unlimited access to all our members-only content. And you can do all that right now, this instant. Open up another tab in your browser, lawofselfdefense.com/trial for that 2-week trial membership. It's a good thing to do. All right, so let's jump into first a news report describing this unfortunate event. Let's see. First of all, it's always interesting how the news media decides to characterize these kinds of events, especially in their headlines. Denver police admit shooting man who wielded black marker. Well, the use of admit suggests that there may be some reason why they wouldn't admit it, or they were trying to hide it. There was no effort by the Denver police to hide this shooting. It was fully transparent, this use of force by the Denver police. There's nothing to not admit. It's ridiculous. And I wonder why they said it was a black marker. Does that matter? I don't know. They didn't capitalize black, so who knows? But the facts of the case, as reported in the news media, the officer who shot 36-year-old Brandon Cole thought that the marker was a knife. Denver Police Department chief says. Denver Police Chief Ron Thomas told the Denver Gazette Monday, and I believe this is just this past Monday. Yes, that the officer who shot 36-year-old Brandon Cole thought that the marker was a knife, but that Cole was in essence unarmed, and that makes this tough. I think that's the chief saying that, not the police officer who fired the shot. Poor attribution there by the reporter. When police first arrived on the scene, police said Cole was rummaging around in a car. A 911 caller reported that Cole was likely intoxicated and had pushed his wife from her wheelchair. We'll see the wife next to the sideways wheelchair in the body-worn camera footage when we get there. Thomas, this is the police chief, Denver police chief, said the officer who shot Cole was placed on modified paid leave while the investigation into the shooting continues. By the way, the officer who shot and killed Cole was a female officer. Another officer who attempted to shoot Cole with a taser, this happens to have been a male officer. So the male officer went to the taser, the female officer went to the pistol. The male officer who attempted to shoot Cole with a taser is also on modified paid leave. The officer's taser didn't strike because it must fire 2 probes at a target and both must hit to be effective, said Denver Police Detective Matt Clark. Clark said that only 1 probe fired. That seems unlikely, actually. Tasers as mechanical devices are fairly reliable. I'm sure both probes fired, but they may not have struck. That's a common problem. And once again, incidentally, we have an example of a taser not working. Now, I've not done a statistical analysis, but anecdotally, it appears to me that at best, tasers work about half the time. That doesn't mean they shouldn't be on the belt. It doesn't mean they shouldn't be tried under appropriate circumstances, and this was probably an appropriate circumstance here. But the very low success rate in these kinds of violent force encounters is notable. It's one of the reasons I don't recommend them for civilian self-defense. Officers could be heard calling him by his first name, Brendan Cole, the suspect, trying to de-escalate the situation. Cole did not stop and was shot as he appeared to advance upon the female officer. Behind Cole and in the line of fire were 2 bystanders, a child and a woman who were not injured. And you can actually see the child here in the thumbnail for this video. This is Cole on the left, object in his hand, which turns out to be the marker. The child is in the red circle here wearing the red shirt, and there was a woman standing behind him. And yeah, they were directly in the line of fire. If those rounds had overpenetrated or missed, they could well have struck the people standing behind the suspect here. We'll talk about the relevance of that as well. Denver police said that the female officer likely did not see the child behind Cole. Clark showed a screen grab of view which the shooting officer had of Cole in the moments before she fired her gun, but moments before she was heard telling the woman and the child to get out of the way. Cole was taken to the hospital where he was pronounced dead. A lot of blood, by the way, in the body-worn camera video. So fair warning, when we get to the members-only portion of today's show and I play that video, you'll see a lot of blood splashed on the sidewalk from the bullet wounds. So no surprise he was pronounced dead. Handgun rounds are relatively ineffective stoppers and killers, especially if a victim gets prompt medical care. But when you see a lot of blood immediately, a major artery has been hit. He was the father of 3 children, aged 13, 8, and 7 years old. Yeah, so it's unfortunate he made these life choices. The body-worn camera video showed his wife, Ebony, asking police, "Don't pull your gun on my husband, please." She was on the ground, a wheelchair nearby. Police alleged she was thrown or pushed out of the wheelchair, and then Cole began assaulting his 13-year-old son, whom Chief Thomas said was an important witness. His perceptions are critical, Thomas said. Ebony Cole told the Denver Gazette that her husband was a hardworking man and a good father. He enjoyed his kids, and he adored me. Isn't it odd how the reflections after the shooting appear so inconsistent with the individual's conduct during the use of force encounter? Of course, there will be a civil suit around this event, so it's a found money opportunity. Cole had no criminal records in the state of Colorado, according to a records search. In a GoFundMe to raise funds for Cole's funeral, Ebony Cole mentioned that her husband had his hands up when he was shot and killed. Really? I don't think we're going to see that when we look at the body-worn camera video. But of course, it ties in. There's been a lot of coverage of Michael Brown in the press recently. The hands up, don't shoot case from Ferguson, where the only reason Michael Brown's hands were in an up position was because he was lunging to attack the police officer who shot him, the much smaller police officer. Ebony Cole mentioned her husband had his hands up when he was shot and killed, but that doesn't seem to appear in the video. One officer tried to tase him as he approached the female officer who ultimately ended up firing. Jay Hirokawa, a former Aurora police officer and Denver district attorney investigator who reviewed the video for the Denver Gazette, that's this news organization, said that domestic violence situations are often dangerous for police because people are out of control. They're upset. You have to worry about the victim, too. Sometimes they turn on the officers. Very true. He said that in a split-second decision, the officer who shot and killed Cole likely did not realize that there were innocent bystanders behind him. She probably didn't see anyone in the background. I can see a potential weapon coming out. If her belief is that she was in fear of her life or others, by policy, she was justified in use of force. Let's see. Ebony Cole said that she's hired an attorney. This will be for the civil suit, but would not name that person. So I expect perhaps she has not yet hired an attorney, but I'm sure Benjamin Crump will be happy to assist in this civil suit against the Denver Police Department. All right, so what do we have here? We have Brendan Cole involved in a domestic violence encounter with his, at least the mother of his children, with his wife. He has 3 children. I don't know if they're all with this Ebony Cole, the wife, or not. But in any case, when the police arrive on scene, she's basically kind of sitting on the sidewalk next to a toppled over wheelchair. He's rummaging in his vehicle. He's non-compliant with police instructions to basically allow himself to be investigated for what appears to be what was called into 911 as a domestic violence call. He's very aggressive, as we'll see in the body-worn camera video, very aggressive towards first the male officer, basically demanding a fight, saying repeatedly, "Let's go, let's go, let's go," concealing his hands around his waistline and his pockets, comes out with an object from his pocket, advances on the male officer who's deploying a taser. We'll see the taser in his hand. We're told from the news report that the taser's ineffective again. Then this is all happening basically in the middle of the street. There's a female officer off to the right on the sidewalk, and Brendan Cole will divert his attention from the male officer to the female officer, step up on the sidewalk, and advance aggressively on the female officer with the object in his hand. That's the point at which she shoots him with fatal results. And the object falls out of his hand, rolls along the sidewalk, turns out after the fact to have simply been a magic marker. So it was not what the female police officer who fired the fatal shot thought it to be. It was not a knife. Now, clearly, if it had been a knife, it would have been presenting as an imminent deadly force of harm, right? Which are the conditions for the use of deadly defensive force by the police officer, the classic 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Here, the element of innocence is clearly on the female officer's side. She's engaged in an attempt to lawfully at least investigate a serious crime, domestic violence. And now she's faced with what appears to be a deadly force threat. Deadly force goes to the element of proportionality. Imminence, it's happening right now, so the element of imminence is checked off. Avoidance doesn't apply in Denver anyway. Colorado's a stand your ground state. But regardless, even if it was a duty to retreat state, generally police officers engaged in their duties would be relieved of any legal duty to retreat that might be imposed on a civilian. And reasonableness was the female officer's perception of what appeared to her to be a weapon, a reasonable perception. And that's something that would be evaluated really from the video, other evidence on hand. If all the elements are present, all the required elements are present, we have a valid use of defensive force by the police officer. The fact remains, of course, that it's unlikely someone's going to kill you with a magic marker. So, in fact, for purposes of our discussion, this suspect, Brendan Cole, was not presenting, in fact, as a deadly force threat to the female officer who shot and killed him. Now, you could argue around that. You could argue that he would, even if he had no object in his hand, he still presented as a deadly force threat on the grounds that she had her gun out, muzzle at him, and he was still advancing on her. And if someone gets close enough to touch your gun, folks, they'll take that gun away. It's not very hard to strip a handgun out of someone's hands, especially a presumptively stronger male from a presumptively weaker female officer. Someone reaching for the gun in your hand, it's really no different than if they're reaching for a gun on a table in a deadly force encounter. They're arming themselves with a gun. In fact, it's worse when they're reaching for your gun because they're simultaneously arming themselves with a gun while disarming you of your gun. And a very high percentage of police officers who are shot and killed in the line of duty are shot and killed with their own guns that are stripped from them by violent criminals. And of course, the officers here are responding to a violent call, domestic violence call. They get there. There's a woman next to a wheelchair toppled on the ground. That's not normal. It would suggest that force was used upon the woman. The suspect's being completely non-compliant. Taser's not working. Advancing on the female officer, even if he's barehanded, could reasonably be perceived as a deadly force threat. But let's set that aside. Let's pretend for purposes of discussion that Brendan Cole would only be presenting as a deadly force threat to this officer, the female officer who fired the fatal shot, if he had an actual knife in his hand and not a magic marker. Does that change anything in terms of the female officer's privilege to use deadly defensive force when it turns out it was only a magic marker, that he was not, in fact, presenting as a deadly force threat? And the answer is no. Because the law doesn't require that the threat you're facing, the threat you're defending against, be an actual threat. It only requires that it be a reasonably perceived threat. Actual danger is not required. Only reasonably perceived danger is required. So she saw this magic marker in Brendan Cole's hand, believed it to be a knife, and she was mistaken. She made a mistake in her evaluation of that use of force event. But mistakes are permissible in self-defense, folks, as long as they are reasonable mistakes. So I want to pull up some Colorado law here, just because this event happened in Denver, Colorado. But these legal principles are the same in all 50 states. Of course, it would be in different statutes, different jury instructions, different case law, court decisions in different states. But the underlying legal principles are the same. That's self-defense law is about 80% the same across the 50 states. this is an example of that. But for purposes of our discussion today, we'll just use the relevant Colorado law. Now, this is from our state-specific course for the state of Colorado. We have these for every state. I put a little banner across the bottom of the screen here. You can find the state-specific course for your state at lawofselfdefense.com/state. I think they're actually on a 60% sale right now, if that's of interest. I say that the self-defense law is 80% the same across the 50 states, and that's true. It reflects how old and well-established self-defense law is, really thousands of years old. But the 20% that varies matters. The 20% that varies can mean the difference between a conviction at trial and life in prison without possibility of early release and an acquittal at trial. You walk out of court a free man, or you never get charged in the first place because your conduct is so obviously within the legal boundaries for your state. So I do encourage all of you, although many of the principles, the doctrines we discuss are generally applicable across the 50 states, you really ought to know the state-specific law for your own state and any other states that you plan to visit, especially ones that you visit on a regular basis. And you can find your state-specific course at lawofselfdefense.com/state. All right, so let's step through this for Colorado. And this is, these slides are taken directly from the Colorado-specific course, as you might imagine. Of course, the 5 elements of self-defense, we discuss them all the time. You can get, by the way, what I'm holding up here is a free PDF download cheat sheet for the 5 elements of self-defense. If you don't understand these 5 elements, you can't really understand self-defense law at all. So we make this 5-element cheat sheet available for free. We don't charge a penny for it. You can get this at lawofselfdefense.com/elements. And I urge you to do that, lawofselfdefense.com/elements. Innocence, imminence, proportionality, avoidance, and reasonable. Innocence, are you the lawful actor, not the unlawful aggressor? Imminence is the threat you're defending against, either in progress or immediately about to happen. Proportionality, if you're using deadly defensive force, generally speaking, you need to be facing a deadly force threat. Otherwise, you've gone disproportional. Avoidance, if there's a legal duty to retreat, you're required to abide by that legal duty if it's safely possible to do so. And reasonableness, did you genuinely, in good faith, have a subjective belief that you needed to use this force in self-defense? And was that subjective belief objectively reasonable? A theoretical, reasonable, and prudent person in your circumstances would have shared that subjective belief. Those are the 5 elements in self-defense. As I've already mentioned, they're all soundly present for this officer, with the possible exception that she perhaps unreasonably perceived the deadly force threat here, because Brendan Cole was not wielding a knife as she thought. He was only wielding a magic marker. And reasonableness, this element of reasonableness, really can be thought of as an umbrella element that stands over all the other elements. Everything that you're perceiving, that you're deciding, that you're doing in self-defense has to be the perceptions, decisions, the conduct of a reasonable and prudent person. And in every state, when you look for this element of reasonableness in your state's self-defense statutes or case law, you'll find it everywhere. Often there are multiple references to reasonableness in a single sentence, as we have here. We have this one initial long sentence in the Colorado self-defense law, statute 18-1704, and reasonableness is referred to twice in this one sentence. And that reflects the importance and weight that the law puts on this element of reasonableness. So, as is common in many self-defense statutes, the way Colorado structures theirs is they have multiple paragraphs in the self-defense statute. The first paragraph deals with mere physical force, which means non-deadly force in self-defense. The second paragraph typically deals with deadly force in self-defense. So in the first paragraph, before you can use any degree of force, however slight, certain conditions need to be met. These conditions, the 5 elements of self-defense, we'll see them all here. And before you can use deadly force in self-defense, there are additional conditions that must be met. Specifically, that the threat you're defending against has to be a deadly force threat, so an escalated degree of the element of proportionality. So in this Colorado statute, we see in this first paragraph the non-deadly force conditions, except as provided in sections 2 and 3. Those would involve deadly force. A person's justified in using physical force. Note that it doesn't say deadly physical force. Physical force upon another person in order to defend himself or another, a third person, from what he reasonably believes to be the use or imminent use of unlawful physical force by that other person, and he may use a degree of force which he reasonably believes to be necessary for that purpose, except as provided in paragraph 2. Paragraph 2 deals with deadly physical force. It reads, deadly physical force may be used only if a person reasonably believes the actor has reasonable ground to believe and does believe that he or another person is in imminent danger of being killed or of receiving great bodily injury, or the other person is using or reasonably appears about to use physical force against an occupant of a dwelling or business establishment while committing or attempting to commit burglary as defined in other statutes. So for our purposes, we'll just focus on A here. You can use deadly physical force when you reasonably believe you're facing a deadly force threat, a force likely to cause death or great bodily injury. That's the definition of deadly force. And here in these 3 paragraphs, we see reasonably believes or some variation of reasonableness referenced in every sentence of the deadly force section of Colorado's self-defense statute. Note that it doesn't say you have to actually be facing or actually meet any of these conditions. It doesn't say deadly physical force may only be used if a lesser degree of force would actually be inadequate, or that the actor is actually facing an imminent danger of being killed or receiving great bodily harm, or that the other person is actually using physical force against an occupant of a dwelling while committing a burglary. None of that's required to be actual. It's enough if it's reasonably believes. Now, that doesn't mean any circumstances would satisfy this requirement of reasonable belief. You have to believe it. Here, in fact, we have both sides. They have to have reasonable ground to believe. So there has to be facts from which you can apply your powers of reason to come to this conclusion, to make a reasonable inference from the facts that you're seeing, the grounds that you're seeing. That's the objective part of the reasonableness, and it continues. So the actor has reasonable ground to believe and does believe. The does believe is the subjective half of reasonableness. What this means is that your belief cannot be speculative or imaginative. So if this officer had shot Brendan Cole and afterwards said, well, for all I knew, he could have had a knife, that would be a speculative ground to believe that she was facing an imminent danger of being killed or receiving great bodily harm. And that would be inadequate. Speculation and imagination is not enough. A hypothetical possibility is never enough to justify the use of force or deadly force. Now, you can make reasonable inferences from facts, from reality that you're actually observing, and you'll need to be able to articulate that. Why did you come to the conclusion that you believe to be reasonable that you were facing a deadly force threat? Well, in this particular case, the officer is going to say, well, I saw an object in his hand that I reasonably perceived as a deadly weapon. It turns out I was mistaken about that. But mistakes are permissible so long as they are reasonable mistakes. There's a big difference between misidentifying an object in someone's hand that they're presenting in a threatening manner, as if it were a weapon. There's a big difference between that scenario, which is what we have here on the one hand, and a scenario in which, well, there's just a theoretical possibility that he might potentially have had a weapon on this person. That's not what happened here. So reasonably appears is enough. Then we have some more conditions for the use of deadly physical force, all reasonableness. Then we have Colorado's Make My Day statute. This is their defense of highly defensible property statute. I won't focus on it here. We've covered it in other recent shows, except to note that, again, multiple references to reasonable belief, reasonably believes in this Make My Day statute. Use of physical force in defense of premises. Again, defense of property, particular kind of property, premises here, obviously. Again, reasonably necessary, reasonably believes, not actually, reasonably. Use of physical force in defense of personal property, reasonably believes, not actually, reasonable. We get to the jury instructions, and these simply reflect the statutory language. So I won't go into all of those. I do have a bit of case law here. Let's see. Not that one. I have another one. Yes. Okay. So Colorado Supreme Court decision, People versus Lavoie, reads, quote, a person assailed may act on appearances when a person has reasonable grounds for believing and does in fact believe the danger of his being killed or of receiving great bodily harm is imminent. He may act on such appearances and defend himself, even to the extent of taking human life when necessary, although it may turn out that the appearances were false, or although he may have been mistaken as to the extent of the real or actual danger. So mistakes are permissible in self-defense, and it's still lawful, privileged self-defense if the mistakes are reasonable. They can't be speculative. They can't be imaginative. They can't be irrational. As long as they're reasonable, however, mistakes are permissible in self-defense. And that's, of course, what we're really dealing with here. So, does it matter that Brendan Cole was presenting with a magic marker instead of the knife that the female officer who shot and killed him perceived he was wielding? No, legally it doesn't. Doesn't make any difference. So long as you would agree that her perception of the marker as a knife under the circumstances was a reasonable perception. And we're going to look at the body-worn camera footage in a moment. And I think most of you would agree that under the circumstances, and of course, by the way, were the state to charge this officer with an unlawful killing, her defense would be self-defense, and the state would have to prove beyond a reasonable doubt, beyond any reasonable doubt, that her perception of the marker as a knife was an unreasonable perception, that a hypothetical, reasonable, and prudent person would not have shared that belief to a jury who's also going to be shown this body-worn camera footage. And it's just not, that's not a realistic prospect, given the way this marker was being handled by Brendan Cole. He was not using it to draw on something. It was not being handled as a marker. It was being handled as if it were a weapon, as if it were a knife, which of course simply augments the reasonable inference that he's advancing on you with a knife. All right, folks, we're going to go into body-worn camera footage now, which means, because I don't want to be demonetized on YouTube, we're stopping the non-member streams of today's show. If you're watching on YouTube or Rumble or Twitter, thanks for joining us. Hope you learned something. But now we're transitioning to the members only part of today's live stream. Hey, how about this? Become a Law Self-Defense member for just 99 cents for our 2-week trial. Gives you unlimited access to our many, many hundreds of blog posts, videos, podcasts, of use of force analysis of real-world use of force events, much like the content you've been watching up to now. 99 cents, folks. I know you have 99 cents. 2-week trial, 200% money-back guarantee, negative risk opportunity. And if you stay a Law Self-Defense member after, not only will you get to continue to get all of this members-only content, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law Self-Defense member. Plus, as a Law Self-Defense member, you get transcripts of every show embedded in the blog post version of every day's show. They're both in text form in the blog post for those of you who prefer to read rather than watch, sometimes an hour-long video. And you get the transcript as a PDF download for your own records. So download it, print it out, 3-hole punch it, put it in a binder, save it on your computer, however you like to do that, as documentation of what you've learned in consuming our content. Because if you can document what you've learned, you can get that admitted into court as evidence for the jury to help explain why your decisions in self-defense were reasonable. And the jury effectively becomes as educated as you. and can understand why your use of force decisions were reasonable. Whereas absent that information, absent your ability to document your specialized knowledge, things like what you've learned in the course of consuming our content, if you can't document that you did any of this, that you learned any of this, that's not admissible as evidence, and the jury will never know it, and you'll end up with a jury that's ill-informed, ignorant of the relevant use of force law knowledge they need, that you had, the knowledge they would need to understand why your decision-making was reasonable and lawful, and one that's easy to manipulate by a prosecutor into a unjust guilty verdict. Don't do that. Download the PDFs of the transcripts. Also, when we get to the end of the show, we do go over comments and questions in the chat, but only in the members chat. So not in YouTube, not on Rumble, not on Twitter. And again, the members chat is part of the live stream of today's show on the members dashboard, which you can access immediately once you become a Law of Self-Defense member. Take advantage of this 2-week trial at lawofselfdefense.com/trial. And if you're a Law of Self-Defense member, don't go anywhere. We're continuing the show. But if you're on YouTube, thanks for joining us. Hope you learned a lot, and I'll talk to you